Well, hello everyone on the West Coast, and good afternoon everyone on the East Coast. This is Ryan Thurman with Contact Center Compliance, also known as DNC.com. With me today for today's webinar on the long-awaited update from the DC Circuit Appeal is Martin Cuniff and David Carter with the TCPA Defense Force at Innovista Law. They're out of the East Coast, and they specialize in TCPA defense practices, and we've teamed up with them to break down this 55-page decision, which has a lot of people reading this over the weekend and waiting for kind of expert legal opinion, as well as an interpretation of how this could potentially impact their business. While you were registering, we had a poll that we're going to bring up later about how this has impacted your business and to what extent, and we'll share those results. It'll be interesting to see how that'll shake out. My company is Contact Center Compliance. We've been involved with TCPA for almost 20 years now, and we try to be at the forefront in educating our customers and people in the industry about some of the changes that are going to impact their not only dialing strategies, but also their scrubbing and data suppression technology. So I'll talk a little bit more about that later today. Just as a side, as we do a lot of these webinars, we always like to put in a plug that while this is good information and certainly things that you're going to want to know about from a legal standpoint, it's always good to retain competent counsel, and it's not a substitute for doing so. So there's our disclaimer, just so you kind of know what's coming. I've been working with Innovista for the last couple of years. We do a lot of work together with clients that are struggling with a lot of these TCPA interpretations, and thankfully they've been able to kind of guide them on the right path. But we kind of got everybody's been waiting for the DC Circuit opinion for quite some time, and I think there's some good news and some things that are definitely kind of a wait and see approach, but at least from the standpoint of some decision is better than no decision, I think a lot of people are happy, and a lot of the trade groups that were involved. So we're going to kind of take a look at some of who the players were, where this came about, look at some of the history of how this really came to be and why this is so important based on the 2015 order. We'll look at some court rulings that kind of indicate how the FCC and how some of these TCP cases may go, and then we're going to round things up with a Q&A at the end, so we'll have some time for some questions. If you've got those teed up already, go ahead, by all means, put them in the chat function so we can tee those up. And also with the information today, we are going to also send that out in a deck that you can download, as well as a link to the recording. So don't feel like you have to take down every piece of information. We just ask that you keep it to your company specific. With that being said, I'm going to turn it over to Martin, and he's going to kind of kick things off and get us started today. So appreciate everybody joining.
Great, Ryan, thank you very much. Just a little bit of background. I know most people on the call know the story, but the DC Circuit's opinion came from 21 separate petitions for either rulemaking or requests for clarification, resulting in the July 2015 FCC order. Then some of the petitioners took an appeal of that to the DC Circuit, and the DC Circuit is kind of uniquely qualified to handle agency appeals like this. They have jurisdiction over most agency actions, and they have a lot of depth of experience in administrative law. So it's the natural place for it to end up. You see some of the logos of the parties who are either petitioners or interveners, and really, since there wasn't a real standing challenge to anybody, frankly, the exact identity of the petitioners here wasn't critical to the decision. I was at the oral argument, and the chambers were packed, so the DC Circuit knew that there were a lot of interest from a broad swath of industries on this. I would note that the the ruling does not address any FTC rulings. This is only FCC stuff. Again, the panel, Sri Srinivasan was the chair of the panel. He also wrote the opinion. He's probably one of the smartest lawyers I've ever met, very well regarded in the legal community, and really kind of in a bipartisan way. He has been on the short list for Supreme Court appointments, obviously by the last administration, not by the current administration, but a very bright, kind of well-reasoned jurist. Cornelia Pillard is also very well regarded, appointed by Obama in 2013, but very bright. At oral argument, she asked some very good questions. In fact, she was kind of focused on the whole smartphone issue. And then Harry Edwards, a more senior judge, very bright. My guess is wasn't too involved in the writing the opinion, but probably played a kind of an influential role. So you had a very good panel here with a very well-written, well-reasoned decision.
Great. So we're going to talk about 4 primary issues out of this decision. The first being the definition of auto dialers or automated telephone dialing systems. And for those of you familiar with the FCC's 2015 order, the key issue here is around how the FCC sought to interpret the word capacity within the definition of ATDS. And this issue became really a sticking point, I think, if you read the decision, because the FCC's 2015 decision tried to extend this definition and therefore apply the TCPA to a broad class of dialing systems, and including smartphones. And the FCC, in their 2015 decision, notably did not argue that the expanded definition would not include the average everyday user's smartphone. And indeed, it appears from the record in the case at the appeal that the FCC's lawyers also did not try to argue that the definition was not so broad as to encompass that particular definition. So the arguments that were presented was that the FCC had expanded and gone too far in focusing on the potential capacity of a device to dial random or sequential numbers as compared to the present capacity of that device. And then there were also some arguments that were made around the First Amendment issues. The DC Circuit, in issuing its decision, really again focused in on this notion that the FCC's expanded definition could capture and require advanced consent for everyday users of smartphones. And they really concluded that that could not have been the intention of Congress, and that the FCC was engaged in overreach. And I think it's important to note that the current chairman of the FCC, Chairman Pai, when he was not the chairman and when the order was originally released in 2015, he is among those people that made this argument that the expanded definition could reach out and really impact regular people making phone calls. And so when he became chairman of the commission, it appears relatively obvious that he is happy about the fact that the DC Circuit has struck down the FCC's 2015 order in this regard. Some people have asked, well, what does this mean for the future? And from our perspective, I guess you have a couple different things that you might see happen. First, it is likely that courts who are faced with the question of whether a particular device is an ATDS and therefore falls within the TCPA restrictions will probably revert back to looking at the present capacity of the device, looking more at what it's capable of and designed to do today as compared to what theoretically it might be able to be transformed into tomorrow. So I think you're likely to see probably more battles of the experts, so to speak, about whether a particular device fits in the more narrow definition of ATDS that existed prior to 2015. And that will probably be an issue of fact in many cases of litigation as it was prior to 2015. I think the second thing to understand about the future with regard to this issue is that the DC Circuit's decision, because it really does appear to be narrowly focused on the fact that the definition expands into and reaches out to smartphones, I think the DC Circuit has left a window open if the FCC decided they wanted to revisit this issue. And it would be permissible for the FCC to revisit the issue and maybe reach some middle ground between where we were in prior to 2015 and then where they tried to go. And I think as with most agency decisions, the fact that the DC Circuit has found this particular aspect of the order to be unreasonable doesn't restrict the FCC from trying to take a second crack at it. Now, I would say I don't see that being something immediately on the FCC's agenda, particularly because Chairman Pai largely controls that agenda. And I think he's appears to be, at the moment at least, happy with the more restricted definitions. But we will definitely see how this impact kind of plays out, both at the FCC level and then in the courts as they return to the litigation that's been waiting for this decision. So our first result there, again, is that the expanded definition of auto dialers was overturned by the DC Circuit.
Yeah, and I would add that in the opinion, the DC Circuit expressly said that the FCC could fashion exemptions to take smartphones out of the mix, which may, at least in the DC Circuit's point of view, may save the FCC's interpretation of it. And then the DC Circuit also talked about kind of the second part of it, whether you're using an auto dialer to actually make the call, which was not presented in the appeal. And the DC Circuit, kind of as an aside almost, said, well, maybe that's the place to focus in on. And that can often be dangerous when a court thinks they have the thing solved, but it wasn't in the briefing, because then they don't get the full picture. It's kind of a brainstorm that they had. So I would keep an eye on that to see whether the FCC picks up on that, or even litigants in federal court pick up on that. What would technically, what lawyers call dicta, wasn't part of the decision, but guidance from obviously a very influential court.
Right. Yeah, so that's an interesting point there, Martin, that the DC Circuit kind of picked up an issue and discussed it at some length, even though it wasn't necessarily the focus of the appeal or even part of the original decision in 2015. So perhaps a new area of litigation that we might see unfold in the future there. So moving on to the second topic, and I should just say again, we're going to try to move through these relatively quickly. We do know that people have set aside about an hour for the webinar, so we'll try to move through these quickly, but we will save some time at the end if there are questions. So the second issue is reassigned telephone numbers, and this is an issue that has gotten a lot of attention both at the DC Circuit, but also at the FCC even after the 2015 order. And it's a particular issue that Chairman Pai has, I think, focused a lot of his attention on with regard to the TCPA. So the issue that was under appeal was a decision by the FCC to begin imposing liability for TCPA violations when calls or text messages are sent to reassigned telephone numbers. And these are numbers that a subscriber had a telephone number, he turned it in, maybe he wanted to switch carriers or he moved to another town, and then the number eventually gets recycled and put back into service, and therefore a new person has now that telephone number assigned to them. And the question was whether when you sent a text message or made a phone call to a number where you previously had consent to do so, but now there's a new subscriber to that telephone number, then is that a TCPA violation? And the FCC concluded in its 2015 order that there would be liability in those scenarios. And they provided essentially what's called a one-call safe harbor, where they said those people making phone calls have essentially one chance to determine that the number has now been reassigned to a new user, and therefore that number should be taken off the list. And the FCC, in providing that safe harbor, and somewhat ironically acknowledged that there was no present ability for callers to be certain that they were made aware when a number had been reassigned. And indeed, there was no requirement, if someone picked up the phone and answered the phone, there was no requirement for that person to disclose that they were a new user of the phone number and therefore should not be receiving future calls and text messages. So it created a scenario in which it was essentially impossible to fully comply. You could, under existing technologies, and we'll hear some about those from DNC and others, but you could comply to a great extent, but there was still this possibility that there would be numbers that had been reassigned where there was no foolproof technology. And ultimately, the DC Circuit said that was enough to make the FCC's decision arbitrary and capricious and to overturn the decision. And so the FCC, again, concluding that without the ability to track and monitor all reassigned phone numbers, it was then unreasonable to have created just a one-call safe harbor. And they used the unreasonableness of that one-call safe harbor to essentially strike down the whole notion that there would be this liability for reassigned telephone numbers. According to the DC Circuit, it is not clear that had the FCC in 2015 understood that their one-call safe harbor would not withstand scrutiny, it's not clear that they would have decided to assign liability for calls made to reassign phone numbers. And so as a result, the whole package had to be thrown out, and the FCC had to be given a chance to try again. And I think it's interesting to me that as part of the reasoning or rationale that the DC Circuit provided on this particular issue is the later in time actions, those actions that have occurred since 2015, where Chairman Pai and the FCC has been soliciting comment and industry input to potentially develop a reassigned number database and impose sort of obligations on carriers to provide reassigned numbers to the database so that callers could then cross-check and determine with a greater degree of certainty whether or not numbers had been reassigned. And that's an issue that is currently pending. Indeed, the FCC is about to likely adopt a notice of proposed rulemaking later this week that would take the next step in potentially implementing that reassigned number database. And I found it interesting that the DC Circuit looked at the fact that the FCC was going to take up that issue this week as part of its justification or reasoning in striking down the 2015 decision. So that is an issue that's very much still going to be, I think, front and center right now.
Yeah, one very interesting part of the decision in that area on reassigned numbers is that many of the parties involved argued for an interpretation that the TCPA meant the intended recipient and not what is referred to as the called party. So the called party would be the person who is actually currently subscribed using the number that was reassigned, where the intended recipient would be the former subscriber of that number. And the DC Circuit clearly said that the FCC's interpretation in saying that called party meant the current subscriber was supported by the law. It cited to a Seventh Circuit decision, Soppet, and was very clear that according to its statutory analysis under the TCPA, called party meant the current subscriber. So hopefully there will be more FCC guidance on reassigned numbers based on perhaps a registry created or other solutions. But I think worrisome is the state of play right now based under this decision, is that called party under the TCPA, means the current subscriber, and there's no longer a safe harbor. So for litigants proceeding under the TCPA, I think it's probably, at least in the interim, gotten easy to show a violation, and perhaps some rationality will be imposed by the FCC on these reassigned numbers.
I think that's a good point, Martin. I think it underscores the importance of continuing to make sure that companies have a really robust strategy for identifying and trying to remove reassigned numbers from their databases, not to be lulled into a false sense of security that because this issue got overturned, that it somehow improves the state of play for them. I think it actually, as you said, makes it more important than ever that they're diligent about addressing reassigned numbers in their database. So we have, again, the first two areas or issues, auto dialers and reassigned numbers, both being overturned by the DC Circuit. Our third issue is revocation of consent. And this issue relates to the 2015 FCC decision order that says that a consumer who has provided consent to receive calls or text messages must be able to revoke that consent in any reasonable manner. And the 2015 order indicates that the companies making these phone calls cannot infringe on the ability of the consumer to revoke their consent. And the arguments in this particular part of the appeal was that it was really, this was creating an unreasonable or unworkable standard, that if a consumer was allowed to opt out in any manner that they chose, that it imposed a really undue burden on companies to monitor all kinds of different ways in which consumers can opt out, and that was not reasonable given where we are with the technology. And there was a lot of discussion and emphasis, I would say, around a potential that a consumer would try to orally opt out, that they might write a letter. We've also seen a lot of cases where people are trying to, rather than simply replying stop to a text message, which is the universally recognized way to stop receiving those messages, they're using creative language, writing poetry, doing other things in order to really game the system. And this became an issue, I think, in particular for plaintiffs, class action lawyers who would try to generate litigation by sort of opting out, but trying to do it in a way that would actually continue to get them all those messages so that they could accrue damages. So it's become a pretty hot button issue. And then there were also arguments about whether, in fact, the 2015 FCC order had prohibited companies from specifying particular methods of opt-outs by contract, so that you could essentially agree to restrict the manners that would be considered reasonable methods of opt-out. I would say that somewhat surprising result for me here on this particular part of the appeal, because the DC Circuit upheld the FCC's 2015 decision. And it did so in part because in a brief, in the FCC's brief to the DC Circuit, in a footnote in that brief, the FCC argued that it hadn't really taken up the issue about whether companies could, through contract, restrict the methods of opting out. And the DC Circuit also concluded that the issue about contractually limiting opt-outs, as well as the fact that only reasonable methods of opt-out had to be monitored or adhered to, was sufficient to protect the companies. And so they believe that in cases in which people act in a manner that's intended to sidestep the reasonable opt-out processes, that there was essentially already protection there, because that could be found to be unreasonable. And so the DC Circuit, I guess, was comfortable with this level of ambiguity that exists, and with allowing this issue to play out on a more case-by-case basis. And on one hand, I sort of understand that logic and saying maybe we should watch and see how this develops. On the other hand, I think it creates, again, a really murky area for companies trying to comply with the TCPA, because now, rather than having clear guidance on this issue, I think we're going to see, again, a continued evolution of case law. There's going to be fights and arguments about what is a reasonable method of opting out. And potentially, I think there's still room for fights and arguments about whether or not you can indeed contract for only certain methods of opt-out. I think there's language in the DC Circuit's opinion, as well as the FCC's footnote in their brief, that could be interpreted in different ways on that particular issue. And so I guess if I was going to kind of anticipate the future on this issue, I think it's going to be one where there continues to be a number of fights about what is the appropriate opt-out methodology and what can companies do as a practical matter to try to limit their exposure here.
Yeah, and I think too, when you think of courts, reviewing rulings by administrative agencies, the kind of two ends of the spectrum, not to use a pun, but kind of two ends to look at is one is, the agency itself, but then also the courts that are going to have to apply those rulings. And I think what, at least reading between the lines, the DC Circuit might, look more closely at a very technical, ruling by the FCC, because it knows that, federal courts are not all telecom experts, right? But I think in looking at this, the DC Circuit probably thought to itself, well, courts are very good at figuring out what's reasonable, right? And that a development of the case law will, kind of shake out broad categories of what's reasonable and what's not reasonable. And to me, that was, maybe I'm reading too much into it, but to me, might have been the unspoken rationality of what they did.
Yeah, and I think that what the FCC did say is that some fears regarding the costs or expenses of monitoring opt-out requests by companies were probably overblown, and that there would be certainly to the advantage of companies to specify manners of opt-out that they would monitor. And the more ways in which they said, here's permissible ways to opt out, then the more likely it would be that other ways that weren't on that list would become unreasonable, right? So kind of giving a sense that if you're doing the right thing and trying to comply and not making it unreasonably difficult for people to get off the list, that the court should give you some credit for that in thinking about whether you've acted in a reasonable manner. I think the other thing that the DC Circuit said that's important is that they don't believe that every frontline consumer interacting person has to be trained in and this is important wording I think they chose, trained in the details of the TCPA. And so I think that is an interesting choice of words, because they're sort of suggesting that maybe there is still a level of awareness that those people might need on the front lines, but they don't need to understand every nook and cranny of how the TCPA operates. And so I think as companies begin to look at and consider the practical implementations of this order and what they're going to do around opt-out requests, that they still need to confront or think about those questions of what should the terms of service say regarding opt-out, and then what do I want or feel is necessary for my employees that maybe are at the register or at the customer service desk. Do they need to have tools or resources available to them to help consumers opt out of receiving future text messages? I think those are areas that the DC Circuit opinion continues to leave open, and that will continue to be things that companies need to think about in terms of their overall approach to and compliance with the TCPA.
Yeah, and I think one thing to remember is it's very much, it seemed to me, they meant reasonable from a consumer's point of view, not reasonable from a merchant's point of view.
Right. Yes, and so I think that's going to be a key question there is, when the courts take this issue up, are they looking at it, whose side are they looking at it, and what level of expense or burden would the company have to show in order to establish that perhaps supporting a particular opt-out methodology is not reasonable? So I think that again, this is a bit surprising to me because of the practical implications of what this may mean and kind of the continued gray area here. Okay, so we have two parts of the order that have been overturned, and then finally we have come to the revocation of consent area, which was upheld by the DC Circuit. The last area of significant discussion in the DC Circuit opinion was around the healthcare exception that had been created in 2015, and an appeal on that particular issue was limited to Rite Aid bringing the appeal. So this was not an issue that all of the petitioners took up. And Rite Aid's arguments were that the exception for certain types of calls and text messages to mobile phones that the FCC had adopted in 2015 was a restriction on their sort of free speech rights and the ability to communicate with their customers, and that there was a disconnect between the restrictions or the carve-out that had been created for mobile phones as compared to a prior carve-out that had been created for landline telephones. And for those not in the healthcare space, I guess let me just start by saying these exceptions that relate to healthcare, there are multiple exceptions. They are all have some overlapping similarities and then some areas that are different. And so it is an area that's fairly complex to even understand when you can safely rely on the exceptions. We have a e-guide, particularly on healthcare exceptions, on our website where we try to map this out and make it a little bit more coherent, but it is one of those areas that's relatively complex to digest and understand what you can and can't do. And so I think Rite Aid in its appeal was sort of responding to that level of complexity and the fact that this new exception didn't square particularly well with the prior exceptions, and there were these additional issues that they had to take up. And I think they were seeking to try to create a little bit more of a clear and clean line of with regard to these particular exceptions. In ruling on this issue, the DC Circuit concluded that Rite Aid had not proven that the way the FCC handled this issue was arbitrary or capricious, and so it upheld the FCC's decisions. It concluded the fact that the mobile exception was more narrow than the landline exceptions was both reasonable and permissible in this particular context based on what it viewed as really the expectation of consumers to receive certain type of information on mobile phones that maybe they wouldn't expect to receive on their landlines, and ultimately that it was an area where the FCC had a great deal of latitude and that the court would not second guess the FCC's decision there.
Right, and I think there was part of the ruling that has a more general applicability even outside healthcare, because the DC Circuit, I guess Rite Aid had argued that any exemption would have been unlawful because HIPAA would override the TCPA, and the DC Circuit squarely held that no, that's incorrect. The TCPA and HIPAA are two different statutes that provide two different types of protection, and you can certainly comply with both of those. And that would apply to other consumer statutes, things like that, where if you're in a heavily regulated industry like debt collection, perhaps, I don't think you can hang your hat on thinking, specific statutes to that industry would protect you from the TCPA. Clearly, you'd have to comply with both of those.
Okay, so our final scorecard for the DC Circuit opinion is the FCC was overturned twice and upheld on two different issues. And so now the next question is, we have the decision, we've waited quite a long time for it. What does it mean moving forward? And so we're going to pick that up with just a couple points. First, the litigation is not necessarily over, even though we have the opinion from the DC Circuit. So Martin, do you want to talk a little bit about that?
Sure. I mean, there's a couple procedural things. Within 45 days, any of the parties can file a petition for reconsideration or what's called rehearing en banc. Reconsideration is very tough to get. you'd have to show the panel that that there's been some development in the law that they overlooked, or some startling new development. Since I'm not aware of any, I can't imagine they're already out there, but I guess people could try. What might be more likely is a rehearing en banc, which would mean a hearing by all the judges on the DC Circuit. I hate to be in this speculation business. This doesn't strike me as one ripe for an en banc hearing. Those are usually kind of very controversial ones, or even politically charged ones. As much as the TCPA is important to us and important to everybody on the call, it's probably not viewed by the DC Circuit as a kind of life or death decision that the entire all the judges have to hear. Certainly, within 90 days, any of the parties can file a petition to the United States Supreme Court to take up the appeal. The Supreme Court's jurisdiction is almost entirely discretionary, with exceptions that aren't important here. And I definitely don't want to speculate as to whether the Supreme Court would view this as the type of decision they take up. I would say that probably in any given year, the Supreme Court grants cert to somewhere between 80 and 100 cases out of thousands, if not tens of thousands, that they're asked to take up. So whether this is the very focused kind of thing that they would want to look at, I kind of doubt that, especially since the DC Circuit did invite the FCC to revisit some of these issues, and indicated that, especially with the reassigned numbers, that there's technological developments happening, sort of exactly the kind of case the Supreme Court doesn't like to get involved in. They'd like to usually wait for everything to settle down and then be the last word, put something to bed once and for all.
Right, and so in addition to the potential appeals, as we mentioned earlier, there is the potential that the FCC takes up one or more of these issues on remand, and therefore you might see additional notices of proposed rulemaking if the FCC is going to try to address any of these issues again. And as I mentioned, later this week, the FCC is already poised to consider a notice of proposed rulemaking with regard to the reassigned number issue. I think the question we have now is whether, for any reason, the FCC is going to pull that proposed order and make any modifications or changes to it instead of adopting the proposal that's already been circulated. So we'll continue to monitor that issue and kind of look to see if the FCC pushes forward as scheduled, or maybe there's a delay so they can just evaluate whether the draft order needs to be modified in any way. I also want to address not just moving forward in the litigation perspective, but also moving forward as an industry. And while we have a couple hundred of you here on the phone call today, I think it's important to revisit a statement from Commissioner Michael O'Reilly, not the chairman, but one of the other Republican members of the commission, from May 2017, where he spoke to the ACA conference and really called on the industry to come together and help the FCC make common sense reforms. And I want to echo that call here. Again, the notice of proposed rulemaking on the reassigned numbers is a particularly good opportunity to do that, but there might be other opportunities presented by this order if the FCC does take up any of these issues for the industry to weigh in. And every time I go and meet with FCC commissioners and the staff in the various bureaus that deal with these issues, the thing I consistently hear from them is how important it is for them to hear from the industry. They get, electronic submissions of complaints about robocalls, tens of thousands of them. Members of Congress get tens of thousands of them. They're well aware of the consumer concern about unexpected or unwanted calls, but where they hear less is from the industry, from the people using the technology, that's attempting to comply with the rules, that's doing everything in their power to make sure that they can reach their consumers in a lawful manner. And if we want to see common sense reforms on these issues, and if we want to see an environment in which people don't have to live in fear of litigation as a cost of doing business, then it's going to take more effort on the part of companies to participate at the FCC and raise their voice there, and talk with them both about how the technology is evolving. I mean, these are individuals that sit in Washington, D.C., and they have some knowledge of how the technology is evolving, but oftentimes their understanding of what technology is capable of doing and how it's being used isn't necessarily up to speed. And so the more the industry is involved in helping to educate them and make them aware of real life circumstances and what's happening to your companies, the more likely we are to be happy with the results and be able to live even with the compromises that the FCC may make. So that's, with that, we'll hand it back to Ryan.
Thanks, guys. You guys did a really good job explaining the different components in there in terms of what got overturned, and definitely I think there's going to be some discussion over this over many cocktail hours from here on out in terms of what the next steps are. What we wanted to do is actually share the results from the poll earlier. We were hoping to reopen it up for the people that came back in, but we had 66% of people respond in terms of how impactful people thought the DC Circuit opinion will be for their organization. So the winner chicken dinner is the impactful one. So I think most people agree that this is going to have some impact in their business. Most people use some sort of technology that allows them to automate their not only their dialing but also their compliance overall. And so adjusting to some of these rules takes time. Things don't happen in a vacuum within large enterprises, and trying to implement technology that allows them to operate in the law is really why I think most companies on this call are not really the ones that the FCC is really after in terms of robocalls and enforcement. So I think there is definitely a lot people can learn from some of the good points in here. Why don't we go ahead and shift gears, talk a little bit about, you can kind of shift to the next slide too, about the one topic that you guys brought up, which is kind of schemes by plaintiffs that, regardless of what direction the TCPA is going, which I think is headed in the right direction, at least a little bit, because it's hard from a compliance vendor standpoint to tell people what they need to do when the rules are kind of a little ambiguous. But the one thing that we've seen has not dissipated is the professional litigator. We just ran a test for an inbound client about 2 weeks ago, and it was strictly inbound leads, and we found out of 22,000 phone numbers, 68 professional litigators, which is an increasing amount on the inbound side. So a lot of these folks that are out there on the plaintiff side tend to be trying to initiate phone calls, and especially ones around reassigned phone numbers. If you want to go to the next slide. Reassigned phone numbers is something that you really have to do almost at real time at the carrier level to get an accurate interpretation. There is a few different things that we check on. Really, the main thing is trying to weed out what we would call a reassigned phone number, where the person doesn't own the phone number, the person that you originally got the TCPA consent from. And so we have a way to actually go into the wireless carriers with a phone number, a name, and verify based on the consent date whether or not a person still owns a cell phone number in particular. I have some clients that are now running that on VoIP numbers as well because of the issues around VoIP around TCPA, which we didn't really talk a little bit about here. We also have ways to verify who some of these individuals are. One of the trends we've seen with some of the litigators is they're not using accurate consumer information, meaning they will give you a fake name or a fake contact information because you may have seen them before and put them on a DNC list. Now they're coming in with a different name, different phone number. So to be able to trace that back around your litigator strategy is also very helpful and interesting to look at. If you want to move to the next slide. So we offer a very unique solution to identify who some of these litigators are, and we also offer the way to provide a reassigned phone number scrub. And the good part about that is that it's accurate. That's the most important. You don't want to misdiagnose wrong number issues, but also provides more of not just a compliance process, but also a data quality enhancement where you're able to remove those numbers that otherwise are not the people you're trying to reach anyway. And so it does clean up data that I've seen reassign rates upwards of 20% on data. So it's definitely creeping up, and numbers themselves are being recycled more often, hence the FCC's desire to have a nationalized database, because that data changes fairly rapidly, and frankly, they're not providing enough access to the data or forcing the telcos to share that information. So you do have some situations where it is almost impossible to trace that information back, and so it's difficult to comply with that aspect of the law. And if you want to go to the next slide, actually, if you want to skip ahead a couple, because I know we're running short on time here, I'm just going to leave you guys with an option that are on the phone today. If anybody's interested to run a check on reassigned numbers, to run a test, or to check on our professional litigator, we do offer free testing where we can help you try to isolate some of those issues and kind of do a proof of concept based on our technology that we dish up via batch or API. I'm going to move it over back to Martin and David so we can get into the Q&A, because I've seen a lot of questions come in here that are particularly interesting, not just from a vendor standpoint, but just someone who works with a lot of clients. So the one question that came in that was interesting was how this ruling impacts click to dial or click to call in terms of being subject to TCPA.
Yeah, so I think that with all equipment that might fall into the category of an automated telephone dialing system, that we're likely to see the courts revert back to looking at the question from based on the present capacity of the particular device, and unless the FCC tries to take up the issue and do something different with it. And so from that perspective, what I anticipate from a litigation aspect of this is that if there's an allegation made that a click-to-dial device is an ATDS, that you would essentially have the burden of proof to establish that it's not capable of dialing random or sequential numbers and storing those numbers. And so much like the universe that existed prior to 2015, that often would become an issue for which experts would disagree. And plaintiffs' experts will probably take the position that it certainly has the capacity to be a ATDS, and therefore should fit within that definition. And then you may, depending on the particular device, there may be experts that take a different view on that issue, and then it often would become potentially a disputed fact. And so without knowing the particulars of any piece of equipment, it's sort of hard to make broad pronouncements, because a click-to-dial device is not a one-size-fits-all definition of what that actually means in terms of the actual piece of equipment that you're using. So it would require some additional analysis.
So the other question that came in was kind of related to that in terms of the question was, do you think the FCC 2003 ruling regarding predictive dialers as ATDS is in doubt given the subsequent nearly uniform embrace by courts?
So I don't think that the 2003 decision is really impacted by this 2015 decision from the DC Circuit. the 2018 decision reviewing the 2015 order. I don't think that that's directly impacted. I think, again, what you're likely to see is a bit of uncertainty really with the courts about what to do now that that portions of the order have been overturned. And certainly a good argument that reverting back to and looking at that 2003 decision is the right way to go, and it's the right way to move forward unless and until the FCC sets or adopts new rules. But I think you're going to see that there wasn't, from my perspective, a number of courts have taken different views on exactly where the line is between currently being used as an ATDS or capable of being used as an ATDS or potentially has the capacity. There was, I think, a pretty gray zone in there anyhow before the FCC's 2015 decision, and I think we're going to kind of return to that state of law where courts are trying to decipher and interpret exactly how to apply it in practice, right? That there's going to be factual questions perhaps that get raised about what a device is really capable of, and the courts are going to have to make decisions on that issue.
So a good question to follow up on that one was basically, when does this ruling take effect, since it's an opinion presently?
Well, I think that you could, again, as Martin outlined, there's the potential that someone seeks an appeal or a petition for reconsideration or hearing en banc or tries to appeal it to the Supreme Court. But unless it's stayed, I believe it's effective immediately. So unless there's some subsequent order that stays the enforcement of this order, then it is essentially the law.
Question was, if there's an appeal to the Supreme Court, what party would appeal? Not the current FCC, correct? Would it be the ACA?
Yeah, it would be one of any of the, the actual parties to the appeal. And, in addition to the ACA, there was, I think if you remember one of the earlier slides, 6 or 7 other parties. Sirius XM, people like that, they would all have standing to file an appeal.
Yeah, and just to clarify on that, it's technically possible the FCC could appeal. Like the FCC did lose half the order, and they would be within their rights to seek an appeal. But I think as a practical matter, we're unlikely to see that from this particular chairman, and he would be heavily involved in that decision. So I think that's unlikely, but not technically impossible.
Right. Extremely unlikely.
Was there any sort of impact to the exemptions for nonprofits?
No, neither the 2015 order or this DC Circuit opinion in any way touched on that particular exception for nonprofits. And that it's important to note that the nonprofit exceptions are actually more, unlike many of the other exceptions that have been created by the FCC in recent years, the nonprofit exceptions are actually part of the congressional statute, the actual TCPA language itself. So I think those are probably pretty safe.
What's your guys'
and again, we have I'll just add, again, we have a TCPA exceptions e-guide on our website that goes into more detail about the exact scope of the nonprofit exceptions.
It's a long question. Sorry, I'm reading it. Basically, the question was, how long do you think it'll take before the FCC provides a safe harbor in some sort of database or actually provides some sort of solution? Obviously, we provide one here, but it comes with some degree of an expense. It's not as expensive as it was 2 or 3 years ago when the order first came out. Prices have definitely come down when it comes to reassigned scrubbing, but I think having it's not just that, it's the accuracy of the data. If FCC has the be-all, end-all database, that definitely helps companies comply with an order that is kind of a little outdated.
Yeah, so that's a good question. Let me talk about that for a moment. The proposal that the FCC has put out for comment and that it may adopt this week or it may decide to delay a bit, it is still exploring, I think, really two possible avenues, primarily two avenues. One is a single unified database that would be run by some agency that the FCC designates, and by that I mean like an entity. And so this would be on par, for those familiar with the telecom space, with the local number portability database or other industry-wide databases that the FCC has created in the past. And therefore, there would be one solution that everyone had to use if they wanted to be eligible for a safe harbor. The alternative proposal that the FCC is still considering is recognizing that there are a few different players in the ecosystem already, including DNC. The FCC is considering the alternative of having multiple approved database providers that would each be able to provide you with the service and make you eligible for some form of safe harbor. The FCC has not finalized a choice on that issue, and there is time for people to weigh in on that question. So I think it is a very important issue that people should consider being involved in. And then I think in terms of timing, I always hesitate to speculate when the FCC will do something, but I will say that I think there is momentum on this issue. I think it's a priority for the chairman to move forward with some proposal on this issue and get something finalized. So if I was to guess, you might see some form of additional action on this issue in the next 6 to 9 months by the commission. And then there would be the practical question of implementation, which is how long is it before all carriers are required to report their data to this database? And if the database needs to be built because it's going to be a single database or something and not just continuing an existing service, then my guess is you're really looking at 2 to 3 years or more before you have a database that really captures the entirety of the reassigned numbers. And that's probably even conservative, or aggressive, I should say, excuse me, in terms of timing, just knowing how these things work in the industry. So I don't think there's going to be an immediate solution. I think this is going to be a problem that continues to linger for at least a couple of years before it's fully resolved.
Thank you for that detailed analysis. I really appreciate both Martin and David joining us today. I think we're going to kind of wrap things up because I think we covered the main questions that kind of pertain to some of the subject matter. We have a couple things coming up to keep you apprised of other things TCPA related. We're probably going to do another series of couple webinars on this particular ruling as we get some more information and some other expert analysis. We also have a TCPA compliance summit in July 10th in Chicago. That we're also, one of the speakers is Joe Bowser from Innovista. Hopefully you can join us. It's downtown Chicago. We'll also have some folks, including myself, out at the PACE conference in April. Their annual conference is coming up out in outside of Atlanta. So another good opportunity to cross paths. And just want to thank Martin and David for putting together this information kind of at a short notice. This kind of all came down the Friday right before St. Patrick's Day, so hopefully it didn't interfere with too much of your festivities out there.
Our pleasure, Ryan. Thanks so much for letting us join you.
Yeah, thank you so much.
It's been a pleasure.